Yes.
Oh my lord. We were on my sixth principle, which was that there was nothing express in the language of Regulation 26.2 that requires...
Yes, just before you get on with that, we've been given some new materials, haven't we? These both come from, do you, Mr. Brown, are they?
There's two from me, which are from the individual claimant's claim, so the basic details of the claim, and then the journal.
You can talk us through them in your reply, so far as necessary. And this is IC, and this is Regulations 5 and 6 in the, as it were, what I old-fashionedly call the Queen's Princess copy, or more accurately, PDF.
But terrible suck-ups that we are.
Yeah. Okay. Thank you.
So, we're on my sixth principle,
Yes.
Nothing express imposing any requirement, condition, or other matter of that kind, such as to provide an express hook for a jurisdictional requirement in section 26.2. Let's have a look at the language of the provision a little bit more closely. Page 89 of tab 6 of the authorities manual. The first point to note is that the default rule in 26.1 is itself expressed to be subject to the following provisions of this regulation. The second point to note is that the only indication of any reference to time is in 26.2 in the first clause. It refers back to 26.1. where the claim for universal credit is not made within the time specified in paragraph 1. And you have my point, which is that doesn't actually make any sense, because the time specified within which is not a time specified within which you must claim within 30 days. 26.1 is a provision that says the default is prospective only claims. Then you have my point about the to and from, the date which the claim is made, and we say it must be from because of Regulation 6. Regulation 10. There is nothing in the language of the balance of 26.2, 26.2a or b in particular, that suggests that there is any burden of proof or requirement to do X, Y, and Z on the part of the claimant. We can see a compare and contrast with the language of the previous provisions in some of the earlier Commission decisions, which had express terms to that very effect. If you want to do that compare and contrast now, you can look at the terms of the 1981 regulations in tab 4. The relevant timing provision in those provisions is at page 45. And if you look at Regulation 5 of those 1981 regulations, which informed the earlier Commission decisions, you can see 5.1, page 45, aligns relatively closely with 26.1, except that it's got the words no later. That was the only other textual change I could identify. But when you come to 5.2, which is the potential analogue with 26.2, it's very differently expressed. It requires a claim for a pension or allowance being made in respect of a period earlier than the day on which it's made. So express reference in the language to a claim for a period. Then the deeming rule, and then in the body of A and B, there's a requirement, express requirement for the claimant to prove throughout the period there was a good cause. And you can well understand why it was that in relation to those very differently worded regulations, and it has to be said in relation to benefits that operate in a very different way to universal credit, why different conclusions may have been reached. But it's a useful compare and contrast to see the type of language that you'd expect to see in Regulation 26.2 to found any submission that there was some express requirement therein. There isn't. Then you've got 26.3, so back to page 89, And it just sets out the circumstances of impairment or vulnerability that mean that you might benefit from the relevant backdating rule. But then can you look at the rest of the regulation, and in particular 26.4. 26.4 provides that in a claim for universal credit made by each of joint claimants, so cohabiting parties, the prescribed time for claiming is not to be extended under paragraph 2 unless both claimants satisfy that paragraph. Now that language is completely inconsistent with the notion that they have to actively make a claim. It's all about satisfaction on the facts of the paragraph. My learned friend's case would require it to say something unless both claimants invoke that paragraph or apply under that paragraph or something of that kind. And once you appreciate that regulation 26.1 is effectively conditioned by everything that follows, that's conditioned by regulation 26.2 and for that matter regulation 26.4, the submission that there is anything express in this language to support his case falls away. There's literally no support for it whatsoever.
So where does that get us? That means on your case there's one claim and it's the claim subject to the following provisions of this regulation under 26.1.
That's right.
There is a claim that needs
There's
to
a
go in
claim.
there. You do need to put your hand up and say you want it. And then that everything else just hangs off and is consequent upon that.
Absolutely, my lady. And in that respect, one has to ask what is so very different about period in this respect, a claim for a period, because there are any number of other topics that may have a material impact upon the level of benefit in question. How many children are under your care and responsibility, for instance, may affect the level of increments that you receive by reference to children. Suppose that you complete the form incorrectly because you think your eldest child isn't of relevance, but they're in some form of education that means that they are of relevance, or you make some assessment about whether or not you've got sufficient care responsibility, you decide you haven't. If you get that wrong in good faith, obviously you have to declare the facts in good faith, etc. There's nothing to stop you by way of revision saying, I've omitted my eldest child. My eldest child should be included in the form, and therefore I want to get the extra increment for having a third child to my universal credit. Why should period be any different? And that's where we get to the heart of my learned friend's case and my seventh principle, because we say that there is no basis for implying an obligation of the kind that my learned friend seeks to imply. His case here, I think it's fair to say, is founded fair and square upon section 1(1)(a) of the 1992 Act. And his submission, as I understood it, was, well, there must be such a requirement because section 1(1)(a) requires you to specify the period for which you require the benefit. But if we go to the language of section 1(1)(a), tab 1, page 3, there is nothing in that language that requires you, and it's back to my first principle, to do anything other than make a claim for a benefit and to do so in the manner prescribed. We go back to my point, we have made such a claim and it is in the manner prescribed. It is by completion of the form that's been prescribed. We've done absolutely everything that's asked of us in order to complete a claim. And indeed, my learned friend's case is that in order to make the claim, we have to do something that isn't prescribed and is entirely outside the statutory system. In other words, make a journal entry, either on the original claim, or if we spot the matter within a month, in a second claim, which we complete in exactly the same way, and then fill in a journal entry there. What's more, all you need to do is look at the list of benefits.
I don't think, does he say the second version? I thought all he simply said, suppose you spotted it after a fortnight, you just put in the same journal entry. You don't have to make a fresh claim. You just attach it to the previous claim or
That's
related.
the first way. The second way was that you make a distinct claim, but then that runs into the rock.
If he said that, I didn't pick that up.
Yeah.
Yes, he did say that. But the rock you run into is the twofold rock of one, you're probably going to be too late by the time you spot it anyway. And secondly, you're still hidebound by the content of the claim form and what's valid under the claim form. And that's quite a substantial rock, to be fair, because if you look at Regulation 8, which specifies what you must do to make a claim, that's page 69 of the bundle. It specifies that in order to be effective, you have to complete it in accordance with the provisions in Schedule 2. And then in relation to a telephone claim, it's provided that it will be defective if you don't provide all the information during the call that's required to determine the claim. And there's no suggestion that Mr. Miah's claims are anything other than fully effective. So that's why I go back to the point, it's a bizarre argument to say that we need to make a claim outside the system for making the claim in order to have made a claim. Almost Kafkaesque. But if you go back to section 1.1 and you look at what a benefit is defined to mean in 1.4, page 4, you'll see that there are listed benefits here that have nothing to do with period. So for instance, if you ask for a lump sum in connection with your state pension, that's not in relation to a period. Or if you ask for a bereavement support payment under section 30 of the
Sorry,
pension.
I've lost the page. Page?
Page 4, my lady.
Thanks.
It's the list of benefits in this section and section 2 below, benefit means. And a number of benefits that are listed that don't have any element that are affected by a claim for a period. So it's a very strange thing to infer into section 1.1a that a claim, in order to be a valid claim, has to specify the period when it relates to a whole bunch of benefits like state pension lump sums that are not related to periods. The real truth of the matter is, as found by the majority in the Upper Tribunal, that there is nothing in the express language of 1.1 that sets any requirement as a matter of statutory form to identify a period, and that the most that could be done is using the powers under 5.1b to set a prescribed condition that said if you are to benefit from a backdating time rule, then you must do so by making a claim of the following kind in the following form, raise your hands, etc. And that falls on the rock of my sixth principle, which is that's not what Regulation 26.2 does. And so this whole attempt to answer the case by reference to section 1 is a bootstraps argument that assumes the very thing that needs to be proved, and it then does so by reference to a floodgates argument. And the floodgates argument goes, well, if our construction was wrong, matters that should be being decided upon with relevant information never have the relevant information to be supplied to it. What are we meant to do? To which, with respect, the obvious answer is ask the relevant questions. There is no floodgates problem of the kind Mr. Brown describes if the Secretary of State has a box on the form that proactively seeks information from the claimants that is relevant to the 26.2 and 26.3 topics. And it's at that point I do invite you to look at the leading case of Kerr and DSD Northern Ireland in the Supreme Court. Tab 17 of the authorities bundle. It's a case with a fairly difficult or complex factual background. Effectively, the claimant was one of 3 siblings who was notified by the police that his brother, from whom he was estranged, had died. He paid for his brother's funeral, and the question was whether or not, effectively, the fact that there were 2 further siblings from whom they were both estranged, the dead brother and the brother who paid the funerals, were relevant to whether or not the bereavement payment was due. And the case therefore basically turned upon who had relevant duties of investigation. We rely on it in particular for, first of all, the dicta of Lord Hope of Craighead at paragraphs 14 to 16, page 254. Perhaps the simplest thing to do is to ask you to read that.
Yeah.
Is it 16.2 in particular?
It's the interaction, my lady, of 16.2 and 3 with 16.4. Because no doubt my learned friend is going to say regulation 26.2 is an exception and therefore we have to prove all the facts. And that's a question of construction. And if on our submission it's no more than a topic for inquiry, mandatory inquiry, because regulation 26.1 says subject to the other provisions of this Act. But those are the principles in play. And then if I could ask you to look in particular at the much cited passage from Lady Baroness Hale's speech at page 266. Could I ask you to read from 57 through to 63, please?
57 to
63, and that's at page 266 to 267.
'63, you say?
Yes.
Yeah.
Now, we say those passages together weigh fatally against any attempt to imply the kind of jurisdictional criterion that the Secretary of State needs to find, not least because, to use Baroness Hale's language, this is not a case where the partner in the process has played their part by asking the relevant questions. They've set the relevant form, it's being completed in a manner that leads to the form in question, I've shown you Regulation 8, being effective. There is no defect in the information supplied. In those circumstances, to find by implication, based upon regulation, Section 1, some obligation to specify period is a hopeless exercise. And
Is
really,
it right to construe the requirements of the statute by reference to what the Secretary of State does afterwards to implement them, and, as you would say, implement them inadequately? Because the time the statute is passed, there's no reason to believe they will be implemented inadequately.
Of course, I can't make that submission, madam. I don't make the submission
So,
that
yeah.
the regulations inform the interpretation of Section 1. My submission.
But it's not so much the regulations; it's actually the form of the questions, which are not, I think, specified by regulation, are they? Or if they are, it's by regulation we haven't seen.
It's by means of an order, and that's I think also explained in the GDC.
Is it?
Yes, it is.
So the process we were taking through this morning,
Yeah.
if we looked at some order or other, we'd find that spelt out.
It's in the latter part of the GDC case. There's
Well, I did look at it, but I didn't pick that point up.
hopelessly complex piece of archaeology.
Don't worry,
by Mr.
don't worry
Williams.
at all.
It is statutory.
You're saying you're not making that submission, so fair enough. So just spell out to me You needn't spell out the injustice of the whole situation, which I get.
You definitely
Spell
get
out
that.
how it helps us to construe the statute
So the
and
statute,
the regs.
the statute, for the reasons given by the Upper Tribunal, contains nothing to require the regulations to specify period. That's the only point I can make
Yes,
on
I
the
see.
statute.
Thank you. Okay.
But the point I do make is that when you come to Regulation 26.2, the fact that the same regulations contain in Regulation 8 a process for identifying what the authoritative form is that you have to complete in order to make an effective claim, and that that process has been done, combined with the general principles of investigation set out in Kerr, make it hopeless to argue that Regulation 26.2 nevertheless imposes some further obligation to make a claim by means of a journal entry. And I suppose in a long-winded way, all I'm saying is what Lady Justice Arden said in the next case I want to take you to, Novitskaya and Brent, which is that at first blush, you do everything you need to make a claim for the purposes of Section 1 of the 92 Act by making a claim in the prescribed form that is part and parcel of the prescribed regulations. The Novitskaya is tab 18. The relevant passages in that case of the sisters in my submission are 10 to 11. At page 274 to 275, and then 21 at 277.
Yeah.
To put it another way, if the form, as part and parcel of its mandated questions, had included questions about period, and had, if you indicated an intention to try to claim for an earlier period, had asked you questions about the basis for such a claim, by, let's say, a drop-down menu replicating 26.3, and you failed to either indicate that you did not claim in relation to such a period, or you didn't complete those particular boxes, then your claim might be defective. And that would then be subject to the process of correction identified by Baroness Hale in the Kerr case. But absent that, the claim has been properly made. And that's all that's required. My eighth proposition is that if this is the correct analysis, then all problems fall away. There is no jurisdictional cliff edge that prevents revision. If the Secretary of State persists in their policy of not asking questions or giving an opportunity to provide information germane to Regulation 26.2, then at least a party that is well advised within the time limits for revision can seek a revision and secure payment for the earlier month. That won't detract from the wider position of potential maladministration in relation to the way that the form is set up, but that's not before you today, and that's a matter for another day. But I do put down the marker that the systematic failure to ask for information of this kind is a matter that may raise grounds for judicial review or grounds for complaint on the basis of maladministration. And it's all the more stark in circumstances where the Secretary of State is saying this is a jurisdictional cliff edge.
You haven't, by your clients, got any light to shed on the odd situation that this has been known to be a problem for 40 years, originally a paper problem, now a form problem, online form problem, but it's still basically the same problem. And nothing has been done. I'm not criticising CPAG at all, but you'd think there would have been a fuss before now or a judicial review before now. maybe it doesn't happen very often. I don't know what
It is a
any-
it is a problem. It's a
Is there
recurrent-
any light as to why this problem is emerging for the first time in court in 2023?
Would you forgive me, Mike?
Yes.
I'm told that the problem has altered in its practical significance as the regime of benefit has changed, because under the old system, there were potentially much larger backdated payments that were due and different means by which the entitlements could be raised. And it's become a much sharper issue by reference to universal credit and the way universal credit operates.
I see. Well, we don't try and explain why, but the answer is that there is actually some reason about changes in the structure of the benefits, the
Yes,
structure of claims,
I
why
think
this
that's
has
right.
suddenly become a more acute problem than it was before.
I think that's right, Madam. As to
Thank you.
why the Secretary of State doesn't ask the questions, we have no idea. All that we can infer is that it might have something to do with the importance of fixing the first date of the claim as early as possible, and the benefits from the Secretary of State's perspective of the situation he's advocating is that everything is automatic. There's no need for an individual focused decision by reference to the facts of an individual case. You can simply say the date's supplied by Regulation 26(1), unless someone's entered a journal entry. We don't need to have any individual decision making, and it makes the process, as my learned friend referred to a number of times, more streamlined, more efficient, and that in our submission is not a sufficiently good reason if the requirements of the regulation require these questions to be considered and answered. Now, the reason everything works smoothly afterwards, and here I should pick up a question my Lady Justice Whipple asked me, is because of how revision works. And for that, we need to go back to tab 2 and sections 8 and 9.
Are we still on your principles, or have we moved on from this?
No, this is still the 8th principle. This is problems all fall away, the system works smoothly, revisions pick up problems. The reasons why revisions pick up the problems is, first of all, you look at the decisions being taken. The decisions under section 8, either the decision under 8.1a to decide any claim for a relevant benefit is defined to include universal credit in subparagraph 3.
Sorry, which section are we in?
Section 8,
Yes, but which page?
page 19.
Oh, 19. Sorry, I was on the wrong page. I couldn't find it.
So we're either dealing with the decision on any claim for a relevant benefit, 8.1a, relevant benefit is defined in 8.3, or we're dealing with C, we're dealing with a decision that falls to be made under or by virtue of any relevant enactment. And it might be said that the decision under Reg 26.2 is under C rather than A, and a relevant enactment is defined by 4, and it includes the Welfare Reform Act 2012. So one way or the other, we're dealing with a decision under section 8. So when you get to section 9, which is the power of revision, what can be revised is any decision of the Secretary of State under section 8. So that's 8.1a or 8.1c. And it's at this point the jurisdictional issue intrudes, because if there's a jurisdictional requirement to have made by a certain time a claim in a certain way, it can't be cured by revision, because the facts are the facts. If there's no such jurisdictional requirement to make such a claim, then it's curable by revision, and that's what goes to the fundamental issue of jurisdiction that the FTT decided against my client and the UT decided in our favour.
I didn't understand it to be put against you quite on grounds of jurisdiction. The point made against you on section 9, as I've noted it anyway, is something along the lines of the reason you can't include a claim for inspection as part of the review is because you can't change the parameters of the claim you've already made under section 1. So in other words, I think the point was that you've made a claim, for better for worse, as it is, under 26 sub-regulation 1, reading in something from section 1, and that fixes the parameters of your claim. So that was the way the case was put against you, which isn't quite in the same language or focus as the way you're dealing with.
I think that's a fair point, my lady, but it's still intended effectively to be a jurisdictional bar, because it's something that once done is effectively set in stone. What's set in stone, that's why I called it the claimant specified period construction, because at the starkest version in the original paragraph 13.3, the claimant had to specify the date, namely the first day of the claim and the ground of, and now we've watered it.
Just a matter of labels, isn't it, really?
Yeah.
The point, as you say, it all comes back to the original point. If this is something without which you don't have a claim,
Yes.
then you can't get over that problem by revision. If it is something where you do have a claim, but there's something that's gone wrong and you want to deal with it by way of revision, then that's fine. You deal with it by way of revision.
The best analogy I could think of, and again, my lord's going to think I'm sucking up to his much greater employment law experience than mine. When you're dealing with extension of time limits in a statutory employment claim, obviously the ordinary rule is you present your claim in 3 months, but then there's, for unfair dismissal claim, there's an exception which has to be expressly invoked. You say the claim is presented late, but it wasn't reasonably practicable for me to do so earlier, or if it's a sex discrimination claim, it's just inequitable for me to present the claim later. And that's a jurisdiction that has to be specifically invoked and proven by the party invoking it. And that, as you've seen from the language of the old 1981 regulations, seems to be much more like how those regulations operated. This regulation doesn't have those features. It doesn't require any form of positive action. It doesn't impose any burden of proof. It doesn't do anything to the claimant. It just says if the facts are as follows, then you can backdate the claim.
Okay.
So that's
One more question.
Of
Sorry,
course,
on section 9, and I may be the only person in this room who thinks section 9, but I do. I wondered if there was anything to be squeezed out of subsection 3 and 4, which is the revision. 3 is the revision takes effect from the date on which the original decision was taken, and then 4 tells you in terms that a revision can take effect as from such other date as may be prescribed, which just felt to me like it was quite a hint saying, all this section does cover the period. If we were in that territory, it is amenable to review as to period as to anything else.
I agree, my lady. That's not a point I'd noted, but now, again, sign up that I agree.
Well, that's regulations may provide. So my next question is, have we got any regulations under section 9? And
Well, one of the things that we did copy, and I was treading that careful balance between bombarding you with hand-ups, which is always unpopular, and not. One of the things we got is the schedule to the claims and payments regulations, which you may have seen referred to in the judgment of Mr. Judge Jacobs, and it lists all of the provisions that have been relied upon for the making of the regulations, and it lists section 5.
If you've got them out, why not give them to us?
Okay. They've got. That. I did send this to my learned friend yesterday.
I'm sure.
It was referred to below. It's just an indication in the critical regulations as to the powers that have been used.
Thank you. Okay. Yep. Well, it's just dotting an I or crossing a T. Yes, but thank you. It's always good to do that.
Yes, Mr. Royston, much more quick and to the point than me in answering my lady's question. In the hand-up I gave you first, the DNA regulations 2013. If one looks at regulation 21, that is the regulation made for the purposes of 9.4. You see, it provides
date of revision.
effective date of revision. It takes effect from the date which the original decision would have taken effect had the date.
Important, isn't it?
It is. It makes my lady's point. More fool us for having missed it.
We seem to have different ways of approaching it, but it just seems to me that might be an answer, in part at least, to
Yes.
Secretary of State's way of putting it.
Yes, and what it also shows is that the process. I think this is me just butchering the point you put to me much more simply. The process of revision expressly anticipates the backdating of effective dates as part and parcel of the revision process, which on the Secretary of State's case is effectively impossible. So that's the topic of construction. Let me say something very briefly on the topic of variance.
Hang on, sorry. You said you had 9.
Oh, 90, you're quite right. It's not a gripper, I have to say. Regulations 30 and 36 fit entirely into this scheme, as we explain at 36 to 39 of our skeleton argument. Now, the reason why I make this point is it had been suggested below that somehow regulations 30 and 36 assisted the Secretary of State. They simply don't. All that regulation 30 is about the limitations of amendment. You have to amend before the claim is decided.
Yes.
Thereafter, your only remedy is not amendment, it's revision and appeal. And we do say it's a bit odd that you have something that can be addressed by way of amendment, but not by way of revision and appeal, because they're basically meant to go together. And then as to 36, all it tells you is that the claim is for an indefinite period once you've identified the relevant start date under either regulation 26.1 or 26.2. And so we don't see how those provisions cast any real light on the exercise of construction. The varies point we address at paragraphs 47 and 48, page 21 of the bundle of our skeleton argument. The tribunal,
So which paragraphs of the skeleton?
47 and 48, my lord. Primary legislation does not authorise the limitation contended by the Secretary of State to work and pension. The majority in the tribunal at 46 to 47 and then expressly at 54 said that if there was any implied requirement as to period, it would be inconsistent with the enabling powers under section 5 1A and 1.1A. That's what they say in terms in the ruling at 54, page 71. A stipulation to specify the start date for a UC claim is neither a requirement to make a claim in the prescribed manner, nor to make a claim within a prescribed time. Rather, it's a requirement about the contents of the claim, a matter which is not addressed by sections 1 or 5 of the Administration Act. And we think that that's right so far as it goes. However, we do think there is a potential varies to have imposed some form of prescribed condition for backdating under 5.1b, the provision I took you through this morning. That's the provision that says regulations may provide for treating such a claim made in such circumstances as may be prescribed as having been made at such date earlier or later than that at which it is made, as may be prescribed. It is. And so I'm trying to be reasonable here. I think on reflection, having looked at 5.1b, there would be varies potentially under that section to prescribe certain hoops that you had to jump through in order to invoke backdating. But again, it takes you back to the critical area of inquiry, which is what are the express or implied terms of Regulation 26.2? What conditions does Regulation 26.2 set? And you have my submission, there are neither express nor implied conditions requiring anything of claims. So that's what I wanted to say about varies.
It's beyond just the making of a claim.
Yes. The previous case law, I suppose my headline point here is I understand and to a large degree share the circumspection of this court in trawling through all of the previous case law in relation to similar but different statutory provisions in relation to quite different benefits. And I'm reminded of the remark I had made to me by the same judge on a number of occasions, which is the problem with analogies is that the facts are always different. And that's the position here. I think it's a pretty unsafe exercise when you've seen, as I've shown you, the terms of the 1981 regulations, and you've seen how very different they are from the terms of these regulations. And to an extent here, my case is really defensive because it's the Secretary of State that's saying in paragraph 14 of his skeleton argument that his analysis at 13 is consistent with the analysis in the earlier cases. It's not, because those earlier cases relate to different legislation and different benefits. And what he, in fairness, has to do if he wants to invoke the case law of the commissioners to support his case is address the reasoning of the majority that explains very clearly why the old cases don't assist. And that's the analysis that starts at 72 and following. And in particular, in relation to the critical decision, which is the one referred to in my learned friend skeleton argument, 984, which is a supplementary benefits decision on the basis of the legislation I've shown you, very differently worded, the tribunal give 5 reasons at 62 through to 66 as to why that exercise of reliance is entirely unsafe. And the first, and I say you actually need to go no further than this, the most compelling reason is the substantial difference in language of the provisions identified at 62. But there are 4 other good points.
I'm not trying to stop you if you want to go through them, but
I'm not going to go through them because my learned friend hasn't taken
No,
up the
and
forensic gauntlet.
no, he very nearly didn't go to them at all.
Yes.
He looked at 1 or 2, but in any event, as he did, the point he did make, the Upper Tribunal in this case was obliged to distinguish them to show it wasn't bound, whereas we don't have that embarrassment.
I don't think that's right because there had been earlier but more recent decisions on more proximate benefits which went the same way, and that's what we addressed in our skeleton argument at section C, page 22, because the most recent word on this front was the decision of Commissioner Howard in 1996. Again, a decision of some antiquity. And we addressed that at 49 and following. And that was a case in which RSB 984, along with the earlier case, had been fully considered and distinguished. So, in fact, what the Secretary of State's really trying to do is to revive some old case law in relation to some old legislation in the context of a very different benefit in circumstances where that reasoning has been consistently departed from by other commissioner decisions. I have to say, I'm highly suspicious of the forensic utility of this exercise, and here I do agree with my learned friend. I think the nettle that has to be grasped is really the nettle of statutory construction in relation to these regulations in the context of this benefit, in the full context of the parallel decision and appeals regulations, etc., rather than some attempt at argument by analogy. I'm not sure it's a very fruitful
Well, I
line
don't
of argument.
think we're really encouraging you to do it. It's interesting if there are particular points you wanted to get from it,
No.
that's one thing. But if it's merely feeling that we need to be taken to them all, I don't think we think that.
So the only point I do think I then need to draw to your attention, it was on the hook of the earlier case law that we did raise the alternative case I mentioned in opening, which was that if a time had to be specified, then in the face of silence, you should assume that the claimant was asking for the widest period for which they might get benefit. And that's the argument we make on the basis of Commissioner Howe's decision at 49, 50 and 51. But it is very much an alternative argument. Our primary argument is that we win as a matter of construction. But if that argument needs to be contemplated, we say there are no impossible consequences. That implication is in line with fairness, and it's in line with the care approach of the Supreme Court as to duties of inquiry, etc., and effectively aligns the operation of the regulation with the inquisitorial duties. So that's very much a secondary case. So with that, I think I have very few conclusionary remarks about my learned friend's cases. It was made already. It still is in our submission an argument that proceeds more by assertion than anything else. The foundation stone is section 1.1 of the 1992 Act. And if that foundation stone, the idea that the section requires regulations to require you to identify a period is a bad argument, well, the whole edifice crumbles at that stage because there is really no argument identified by reference to regulation 20.6.2. That being so, all of the complaints about error on the part of the pretty carefully reasoned tribunal reasons fall away. There is in our submission actually very little indifference between the approaches of the majority judges and Judge Jacobs. The majority judges basically conduct an exercise of statutory construction by reference to primary and secondary legislation and arrive at the conclusion I urge. Judge Jacobs focuses on the fact that both limbs of Regulation 26.1 have a very substantial legal component. The legal component in 26.1 is supplemented only by the adventitious fact of when the claimant presses submit on the claim button. That's the only part of 26.1 that's under the claimant's control. He's criticised for suggesting there's any factual element, any factual element in the Regulation 26.1 test. That's obviously wrong. There is a factual element of the date on which the claim is submitted being a matter under the claimant's control. And then what Judge Jacobs says is, in relation to 26.2, that is still substantially a test of law to be applied by reference to the facts as found. What he is very clear on, however, is that there is no requirement for the claimant to do anything to trigger that test running. So there's no requirement to make a claim, no requirement to specify a period or anything of that kind, and none of the criticisms, therefore, in relation to that distinct way of arriving at the same conclusion are sustainable. Can I just check with those behind me if I've missed anything? Unless I can assist further.
No, that's been very helpful. Oh, sorry, I didn't ask my ladies. Yes.
Can I just check? I was just looking back at the U2's decision.
Yes.
Were they with you on your alternative case, really, rather than your primary case, as you put it today?
Now, I think
in other
that
words, the idea that it was for the decision maker to effectively investigate and to work out what the date of the commencement was, which isn't your primary case, as I've understood it before us.
it is our primary case. Primary case is that there is no jurisdictional obstacle.
No, I got that. Okay.
And that's what they found. They found that,
Okay.
that what they didn't do, I think it's fair to say, is take the argument made by Mr. Royston as to an implied period request. So it's the argument at 31.
Mm.
They didn't take and decide that argument because they had decided the case at the first level. So they'd found for the claimant or the argument set out at 30. So they didn't address the argument at 31.
As I have understood your main argument for us, there's one claim, and on the facts of this case, that claim was made on the 16th of March. We discussed how then the backdating, as we've used the shorthand, is
Yep.
something that doesn't require a separate claim in and of itself. But I think you did accept the idea that somebody would have to put their hand up and say, at some point within time, I want to backdate this in order and do it by way of review. Is that
The
right?
Secretary of State, to take my Lord Justice Underhill's point, the Secretary of State has to be told that there are relevant facts if the Secretary of State hasn't found out for himself.
What I want to just pick away at and understand then is, I think in this court we have between us expressed some misgivings about the way in which the online system works. There is, even on your case, then still I suppose a tripwire for claimants, that they've still got to get on with it once they get the decision, because they've only got a month from the decision. In this case, on the facts, it's okay because the mother did, but there is still an issue of sensitivity there.
Absolutely, my lady. The route through found in this case is a small palliative for the problem of not asking the relevant questions, because for every Mr. Miah who's well advised and told you can apply to revise within the revision time limits, there will be many people who will have entitlements under 26(2) and 3 who never apply for a revision in time and are never asked for the relevant information, and those claims will be lost. And that's why, when I say that there is a problem of maladministration here, it arises whether or not we win on this appeal or not.
Thank you very much indeed.
Give me a second. Mr. Royston gives a very good analogy. Suppose the form failed for whatever reason to ask questions about children, and children information has a relevant bearing on what increments you're entitled to. Would that be a jurisdictional bar? No, it wouldn't. But the problems of people having got the wrong award wouldn't necessarily be fully curable by the revision process, because some people wouldn't apply for a revision in time.
Yes, Mr. Brown.
Directly on my lady's point before I make my one point of reply, that the logic of the respondent's position is, as set out in paragraph 35 of their skeleton argument, it's not just the revision. They say it's also when one goes to the tribunal, so it's the appeal to the FTT and thereafter. So they are not saying that it's just an additional 1 month in which they can then bring their additional facts to bear. They say that they can also go to the First-Tier Tribunal, and even if it's not been raised at any stage prior to that, because of the principle that FTT hearings are a full rehearing, then even then they can claim that the original decision was wrong because they present a new argument at the First-Tier Tribunal, and thereafter in the tribunal system, subject to the rules of the tribunal, presumably the argument can come in at any stage. So that is the logic of the respondent's position.
But is that so terrible?
No, that is the logic of their position, just so it is clear. Whether it's terrible or not is not strictly speaking the issue. I'll come back to that in a moment.
Well, perhaps I'll just ask Mr. Delaman, I think that probably is right, isn't it? I'm not sure it's particularly a point against you. You were saying, oh, well, you know, provision works in this case, but it wouldn't in every case. Actually, subject to the time limits for appeal, you could raise this new case at the appeal stage. And I think you say that in the skeleton, didn't you?
You have to have first asked for a revision on some grounds. If you haven't asked for a revision, you can't appeal.
Or if you're out of, how about if you're out of time to ask for a revision?
You can't appeal.
You can't appeal. You'd be out on time grounds.
It's quite complicated. Perhaps I should let Mr. Royston, as opposed to being.
Well, I'm not. If my lady wants chapter and verse,
Yeah. I think it's
I'm not actually sure this really goes anywhere, does it?
I don't
I'm
think it
only
does.
raising it because Mr. Brown did, and we hadn't actually heard you on the question how appeal fits in. For the point of view winning this case, revision is good enough.
Yes.
Because you did apply for a revision in
Yes.
time. If even that is thought to be wrong because there's it's basically amendment or nothing, and once there's a decision, you're dead. Then it doesn't really matter whether we're talking about revision or appeal.
My Lord's quite right. My response is, so what? that you can raise on appeal, that which you can.
Well, maybe Mr. Brown wasn't making a great point about it, but he was just pointing it out. But were you making a great point about it, Mr. Brown? In which case, I'd like to know what it is.
No, just to be clear then. So here then, this would be a unique situation in which one has effectively the whole process commencing by way of the First-Tier Tribunal appeal, because you are not saying that the decision was wrong. How could it be wrong? Because the material or the claim as presented is precisely the claim that you put before the decision maker. You're coming along on our case and then presenting what we would say is a new claim for the first time at the First-Tier Tribunal or thereafter, indeed even at this court potentially, and saying, well, this is my claim. That's how they say this is intended to operate, and we say it's not intended to operate.
That's not particularly a point about appeal. That would also be a point about revision, wouldn't it? It's all the same point. It's all the question whether the claim is frozen at the date that you make a decision, or rather, perhaps that way of putting it is tendentious. That at any rate, the question of the period for which you can claim is frozen at the date you make the decision. And he says, no, it's not, as long as I've got a claim in for universal credit. One of the things that I can ask for a revision about is the period that it covers, just as if I could say I only claim for 2 children, but I realise I could have claimed for 3 because I didn't realise one of them was eligible. Isn't that?
Yeah, so we would not accept that as a relevant analogy, though, because you have 3 children. So when the question is...
Yes, well, this is the point you made earlier,
Yes.
that period... This is really just the fundamental difference between the two of you. You say period is a different kind of concept and is inherent in the concept of claim.
Correct.
So you distinguish between the period covered by the claim and the content of the claim. And he says the period covered by the claim is simply part of the claim.
Yes. He says it is something then which falls to be established rather than something that the individual puts before the decision maker when making their claim. That is the fundamental distinction between us. There is only one point in this case, and it is that point.
Yes.
So it follows that I can make my reply submissions briefly, because of those 9 principles as they're described, at least 8 of them are basically just public law criticisms of the current structure that is in place. And they are criticisms, whether well-founded or not, which are wholly irrelevant to the determination of the question before this court, because it can't possibly be right that if, on the hypothesis, we have not faithfully implemented Baroness Hale's guidance in Carr, that can tell you nothing about the interpretation of the statute. If the respondent is right that there is some maladministration judicial review in the wings, that also tells you nothing about the authentic interpretation of this legislation. This legislation has one authentic meaning only, and that is not shaped by the criticisms of the universal credit structure that may or may not be properly made by the respondents on this appeal. So it forced to be determined purely as a question of statutory interpretation. One has to resist the temptation to identify a problem and then fashion a solution to that problem, because that is not the exercise that is before the court today. The exercise that is before the court today is to try and understand what Parliament means in Section 1 of the 92 Act and the regulations in circumstances where all of those tribunal decisions have approached it on the footing that in this situation, the period of the claim or invoking the backdating is something which requires something to originate from the claimant. We say that is wholly consistent with the way that Baroness Hale approaches this in Carr. It's not a question of burden of proof, that's unhelpful language, because as the Supreme Court, House of Lords tells us in Carr, burden of proof is not a concept that arises in social security, at least not in a formal sense. So we don't approach this on the question of burden of proof. The way that we approach this is on the basis that Parliament intends for there to be certainty in the administration of social security. So the 1992 Act is an administration act. And what that contemplates then is that there is going to be a sufficiently predictable and certain process for the administration of welfare, and that the rules and the secondary legislation that is going to be promulgated pursuant to those powers is going to give effect to that. So fundamentally, we are in the sphere of public administration, and we would say that the starting point should be that the rules are to be clear and workable. And we say that our interpretation achieves that for the reasons that I gave, and they are that section 1, the reference to the claim, does include the period of time for which the claim is made, because it is entirely a matter for the claimant as to when they wish to seek benefit. A claimant can legitimately elect not to seek any benefit for which he or she is entitled for months or years. That is a matter for the claimant. They don't have to request social assistance. If they do, then they have to claim it. So it does come down to this fundamental point. Does that reference to the claim in section 1 then encapsulate this issue? And we say that when section 1 is read with the relevant secondary legislation to which it refers in section 1, it is perfectly clear that it does. So section 1 does set out a principle of claimant autonomy, and that does then mean that you have to identify the date. And that is what fundamentally distinguishes the sorts of errors that are being given by way of example, so errors in terms of the numbers of children and things like that. Those are questions that go to the computation of the benefit to which you're entitled. You have to provide all of that information. It is not within your gift to withhold part of that information or to try and manipulate the award, possibly against yourself by withholding certain information. You've got to provide all of that information about your personal circumstances. You can elect not to claim other benefits, that's fine. But if you're claiming this benefit, you provide the information that is prescribed. Insofar as the period is concerned, the convenient mechanism which is adopted is to assume 26(1) that you are claiming from the date in which you present the claim. That is a convenient, predictable and workable mechanism. It does provide for the advantage of efficient public administration, and there is no reason why I cannot refer to that as being a proper aid to interpretation. This is administration, it's an administration act, it's intended to be administratively workable. So one starts from the proposition that you claim on the day, and that then establishes your claim. But because the legislation allows you, in particular circumstances, to claim something more, in this case looking backwards temporally, then you invoke that. Now, insofar as that's described as jurisdictional, that is fine, but it's just the ordinary operation of the regulations.
I mean, a good thought experiment might be how would we be construing this if there were in fact a question on the online form?
Yeah.
You might say the problem probably wouldn't arise as nobody would care, but nevertheless think about if there was such a form, would we be saying that the natural construction of 26(1) was that you did have to specify the period? There wouldn't be any problem about that because the form allowed you to do so.
Correct.
But that would be an unbiased way of looking at the natural construction of 26(1) and 2, untainted by the fact that because of the way in which the Secretary of State has in fact set up her systems, she's created a problem.
Correct.
Which you say, clients may regret it in 3 months' time, may well have problems, but they're problems that have to be addressed by attacking the whole system by judicial review, not by pretending that the section means something that it doesn't mean.
Indeed. So when one strips out the bias or the prejudice, or however one describes it, one ends up with what is in fact clear. And the respondent goes as far as to say, well, if you had the question, then your legislation would be perfectly fine in the way that you're interpreting it. And that reveals the issue here, that it is a criticism of the absence of a question in the application form which founds this claim, not the statutory interpretation point. And that is a fundamentally different point. There may or may not be an answer to it. That is not my brief today. So I don't need to answer that question. I simply make the point that that is an irrelevant question to the pure issue of law.
Yeah. Okay. Well, it's just a thought experiment.
Indeed.
To clean out the consideration that the way the system is working is it might appear unsatisfactory from the construction of what the statute actually means.
Indeed.
Anyway, okay. Well, I floated that doesn't necessarily mean that
No.
helps you in the end.
I understand, but that is the consequence, and that then does mean that one does give proper effect to Regulation 30, amendment of a claim, because the Secretary of State has gone to the trouble of dealing with amendments to the claim specifically. On the respondent's case, it doesn't matter, everything is all effectively up for grabs at any time when you declare that you're claiming universal credit. Whereas regulation,
but isn't he right? Everything is up for grabs except about backdating. So you have set up a system, and I don't. It's probably the Secretary of State's credit, but which allows claimants the chance to have another go at everything, except you would say backdating, because that's what revision does.
you can amend
Yeah.
if you wish to backdate, because you're then amending your claim.
Yes,
you can,
but
yeah,
but after, I think you were slightly saying. I understood you to be saying that amendment doesn't matter. That the result of Mr. Delamay's submission will be amendment simply didn't matter because you could look at everything again by way of revision.
yes.
But that's also, apart from the question of backdating, that's how the whole system works. Up to decision, you can amend, and then if you forget to do that, or that's a kind way of putting it, if you're not in a position to do that, and then you get a decision, and only then do you realise you've got it wrong, then the rules give you the chance to ask for revision
Yes, they
and
do. Yeah.
appeal. And that's just how it is. And all that Mr. Delamay's submissions would do would be to add one more item to the agenda of things on which you can ask for revision.
Well,
Is that so terrible?
in a sense, I am neutral as to whether that's terrible or not.
Well, it's you who are making the point. I just
Yeah,
wanted
my
to spell out how terrible a point it was.
My lord. We do fundamentally say that this rests on a clear and ordinary
Yeah.
interpretation.
Well, we've got that.
Yeah, you do have that. I think I should just pick up. I think there was a point made by my Lady Justice Whipple in respect of what was handed up in Regulation 21.
Yes.
That doesn't unpick anything at all. That's basically just saying if you're wrong about the date, so let's assume that the decision maker failed to recognise that you had a disability, and the date falls to be then changed, then the revision ensures that that is given effect. So that's dealing with precisely the situation in question. So if it is revised because the original decision maker had failed to appreciate that the criteria under 26.2 and 26.3 was...
So, Reg 21, which we were handed up, talks about on revision, the Secretary of State decides that the date from which the decision took effect was wrong.
Yeah.
It's not to do with how many children you've got and stuff.
Yeah,
It's to do
exactly.
with dates.
Yeah, so if 26.3, 2 and 3 had been satisfied and the decision maker had wrongly decided that they hadn't been satisfied, then it falls to be revised and you get a new date. That's entirely the structure of the scheme. So we're not suggesting...
It's just saying, suppose there wasn't a backdating issue at all,
Yeah.
but as from today, you claim for the wrong number of children, it just 21 merely spells out what you probably assume anyway, but you
Yeah.
need to spell out, that you can claim for the missing child right back to day one, not just from the date of the revision.
Yes, exactly. Back to day one. And if it is specifically dealing with the date, a pure backdating case, so my lord, I agree in respect of children, but if it were purely the backdating, it assumes, though, on our case at least, that you put in issue your earlier claim as part of your claim. So your claim does cover the backdated period. decision maker.
It all sort of folds back into the same basic issue, doesn't
It
it?
does,
That you either
absolutely.
got a good regulation 26.2 extension claim, or you haven't. And if you have, then section 9 and regulation 21, you say we'll let you through, and
Yeah,
the mayor says we're back at where we started.
we're back where we started. So 21 does not do anything that's not contemplated by the structure which we say already applies, which is that if you have expressly or impliedly raised it, you've made the claim, and that claim falls to be determined. If you haven't, then your claim is determined on the material presented because you've not requested anything different, as indeed all of the cases do appear to contemplate. So we say that this is a fundamental principle of social security in the sense that those tribunal cases, Baroness Hale and Kerr, and generally speaking, all proceed on the assumption that an aspect of this nature is something that the claimant would identify, expressly or impliedly, then gets investigated, and that's when the inquisitorial process kicks in. But the stark position of the respondent is that you don't even need to identify it in the first place. And we say that that is completely alien to the regulation system and indeed all of the cases. It does not find any support at all in the ordinary meaning. So that's why we say it's wrong. And that's my reply, unless I can assist the court.
Thank you both very much. We will be reserving our decision. You will get a draft judgment in due course. That is primarily for the purpose of enabling you to agree consequential orders, or if you can't, to make short written submissions on the basis of which we can decide any consequential issues at the time of hand down. But of course, we'd also be grateful to be informed of any typographical or other minor factual errors. There are tight restrictions on how you can circulate the draft judgment. I won't go through those. If you're in doubt, you can put the Counsel General for Wales case. Thank you both and those behind you, all rows, for contributing to an interesting and clearly important argument.